Imagine you have just welcomed a new baby, recovered from a serious illness, or cared for a critically ill family member. You have taken a much-needed leave from work, and now the time has come to return. A key question on many minds is whether your job will still be there. It is a stressful thought at an already important time in your life. Generally speaking, no, your employer cannot legally deny your return to your position after you have taken leave under the Family and Medical Leave Act. The Family and Medical Leave Act, often called FMLA, is a federal law specifically designed to protect your job when you need to take time off for certain family and medical reasons. The core mechanism behind this protection is the job restoration provision of the FMLA. If you are an eligible employee and your employer is a covered employer, the law mandates that you are entitled to be restored to your original job or to an equivalent job with equivalent pay, benefits, and other terms and conditions of employment upon your return. This means your employer cannot simply replace you and claim there is no job for you. The FMLA protects your position for up to 12 work weeks of leave in a 12-month period for qualifying reasons. The purpose of this law is to balance the demands of the workplace with the needs of families, providing job security during these crucial times without fear of reprisal. To make sure your return is smooth, you should first review all of your FMLA paperwork and your employer's policies carefully. Make sure you have met all the necessary requirements for notice and medical certification. When you are nearing your return date, communicate your intention to come back to work clearly and in writing, referencing your FMLA leave. Keep detailed records of all your communications, including dates, times, and summaries of conversations. If your employer attempts to deny your return, immediately ask for the reason in writing. Then, you can use these records to seek advice from an employment law professional or contact the Department of Labor. An important aspect often overlooked is the specific notice requirement for returning. While FMLA protects your job, it is still crucial to provide your employer with sufficient notice of your intent to return, typically to work weeks, unless your circumstances change unexpectedly. Also, be aware of the rare key employee exception. This applies to a highly paid, salaried employee among the highest 10% of employees. If restoring this employee would cause substantial and grievous economic injury to the employer's operations, the employer might deny reinstatement. However, this is extremely uncommon and comes with strict notification requirements for the employer. Knowing your rights under the Family and Medical Leave Act offers immense peace of mind during challenging personal times. By understanding that your employer is generally required to reinstate you to your job or an equivalent, and by taking proactive steps like clear communication and meticulous record keeping, you can confidently navigate your return to work. This legal framework is in place to ensure you can focus on your family or health without the added worry of job insecurity.